Hello and welcome everyone to this new episode in Confidence with Dr. Reddy, powered by Address, which is a real-time environment for the dispute resolution. This session, we'll be talking about institutional arbitration specifically for the construction industry. For this, we have Mr. Amod Dalela, who's the panelist. He heads the law firm Dalela and Dalela, which is based in Delhi. He's also the principal advisor and honorary registrar for CIAC, that is the Construction Industry Arbitration Council. So with this introduction, let's get him on board. Sir, welcome on board. And
Thank you very much, Dr. Reddy. Thank you very much.
Thank you very much. So first, most of us know that what is institutional arbitration is that it is by definition something which an institute takes care of. But what is it specifically? How is it different from ad hoc arbitration? Can you help us understand what is institutional arbitration?
Totally, as the word suggests, there are certain institutions which have been created to conduct the arbitration for the disputants who come to them for resolving their disputes. And these institutions have got certain features and characteristic features, which are like they must have a panel of arbitrators, and they must keep that panel, updated on the knowledge. So the refresher courses they must run for the arbitrators. Number three, the panel which they choose should be of the experts which are required to satisfy the need of the disputants. And then they should have the rules, robust rules, which should be there to conduct the arbitrations. They should have the facility like secretarial assistance, which they should provide to the disputants and the entire arbitration system. And they should have the infrastructure if it is a physical arbitration. Otherwise, as far as the virtual thing is concerned, then there's no need for the infrastructure facility. The virtual thing has come up very recently after the COVID. It was not there in existence before the COVID. COVID has, created the change in the entire system of meetings. Zoom has, these people like Zoom and WebEx, etc. They were not there much before the COVID. So this is of the recent occurrence, recent happening. Problem is that when we talk of, I'm slightly digressing from the subject of institutional arbitration. I've now restricted myself to the online meetings. In any arbitration, if you have online hearings, sort of, you can have, to some extent, you can do justice to the system. Otherwise, when it is the witness cross examination, when it is the discussion on the documents which are bulky documents, then you don't do justice. So this facility, to some extent, is okay, but then institutions which are there in the arbitration system, they have their facilities, they have their meeting rooms, they have their recording system, they have their screens where the organs are typed or whatever. So these are the special features which are there for the institutions. It's a must for them to have. This is about the institutional arbitration, but the institutions which are there, they are different from ad hoc system, because in the ad hoc system there's entire conduct of arbitration rests on the arbitrator or the arbitration tribunal. Party autonomy is there, certainly. But when it comes to the rules of arbitration, it is left to the tribunal, because parties are not competent enough to frame the rules. Whereas in institutional arbitration, you have the institutions which have got robust rules. They maintain the rules and they keep the rules updating depending on the change in law. Suppose there is a change in law, the arbitration institutions are capable of revising their rules. These are the main features which an institution must have in order to sustain in the market.
Okay.
That is how it is different from ad hoc.
With that background, but there's a implied meaning here that the arbitrators that are on your panel of the institution are probably more qualified than ad hoc arbitrators. Not necessarily, which we know it depends on person to person. But overall, I think institutional arbitration brings everything in one place. So if I am a disputant, I don't have to go to 10 places to find a venue, a secretarial assistance, and then an arbitrator, whether he's trained or not. So to that extent, I find it useful. But in the meantime, I have one very quick, maybe a suggestion or a question, whichever way you want to take it. The Arbitration Act, after the 2019 amendments, introduced the concept of institutional arbitration. 2015, but it has not yet been notified. But that institutional arbitration, one of the things is a repository of awards. Would that kind of facility be available for arbitrators? Maybe some of the important information is redacted for maintaining confidentiality, but would arbitrators be able to have access to earlier awards so they will understand, especially new arbitrators, on how to write an award?
Really, already it is the repository is there.
Sir, you're breaking up. You need to speak up, please.
Is it okay now?
Yes.
What I was trying to say is that the repository is certainly there. The institutions they maintain the record, but when it comes to sharing with the other arbitrators in some other case, it doesn't happen that way. Nobody wants to see, but in case there's some assistance required by the tribunal in knowing how it should be conducted, the institutional experts are always there to help them. For example, if there's a tribunal which is conducting a particular arbitration and they need some assistance in knowing how the witnesses should be examined or how the witnesses should be summoned, those type of assistance is certainly be provided by the institutions because the award repository is not required to be shared with the tribunal. But yes, that expertise always rests with the institution. So that is the advantage with the institutional arbitration. But yes, no, I have not seen any where when the old awards are shared with the other tribunals.
Okay. Now, two things that you said earlier. So the first point is that institutional arbitration focuses more on training its arbitrators. So there is continuing education. In fact, in your recent conference, you have given out certificates which contain professional development hours or continuing education hours, whichever way you want to call them. I think that's a nice initiative. Do you want to comment on that? Is it really that required, or do you see any benefit, or how do you see it?
It is actually, if you ask me, honestly, it is we started this system to create interest of the participants to come and at least have some backing that they have certainly attended the program. Uh, the continuous education hours, whatever, are actually to be given by the recognized institution, by not everybody. If you have somebody doing a course somewhere which is not even recognized, and they give you that art certificate, it has got no meaning, honestly. So we try to give it because we are an institution. When we give that certificate, it has got some meaning.
Yes.
But if somebody like a small time institution which has got no backing, which has got no credentials, if they start giving this certificate, it can be an eyewash for the delegates who are attending the program, but it really has got no meaning.
Okay.
So institutions should be careful when awarding this type of thing. We did it recently in Hyderabad, as you know, because you were also there. It's because we think that we are capable of it. We have got some history. We got institutionalized in 2006, and since then we are doing this. We thought it is proper from our side to do it. Otherwise, it has got no meaning if somebody else does it.
So in fact, I got very good feedback about those continuing professional hours, and others want to follow in these footsteps. So congratulations on setting a precedent there. So now moving to the second.
But the thing is, it should come as a word of caution. Not everybody should do it, otherwise it will lose its meaning and charm.
Yes. Fair enough. And moving to the second point, which you said earlier, which is I noted down, is that the institution has rules and you keep updating the rules. So that is where I see a quick conflict. That is, for example, I may enter into a contract with my opposing party when you had the earlier rules, whichever that was, doesn't matter. And then let's say the dispute occurred in the year 2024, by which time you had modified your rules, and I don't like your rules anymore. Now I'm in a suit because I've already chosen your institute with these rules, but the rules have been modified. So that's a catch 22, but I think, I mean, unless you have some comment on it, it's just an observation from my part.
What I was trying to say is the rules, both set of rules are applicable. It is for the wisdom of the tribunal to choose the best part suited to the requirement of the particular dispute. Nobody says that if you have a particular set of rules, you cannot go and adapt something from the other set of rules. So both are available. If it has changed, nobody says that only previous one will apply and the new one will not apply. So it is for the tribunal to adapt the right and pick the portion which is suitable to the dispute in question.
Okay. Now, how do you see these institutions' roles changing? How was it 5 years ago, 10 years ago, or 20 years ago? And how do you foresee things happening in the future, in the next coming 5 to 10 years or 20 years, whatever is your vision?
Your question, Dr. Reddy, has got two parts. The historical part of the institutions and the future. The history says that there were some institutions which were affiliated or are affiliated to some industry association. Those were doing fine, like ICA, which is the part of FICCI, and CIAC, which is part of Construction Industry Development Council. These institutions have got an advantage that their industry associations and the members of those associations, they keep coming to these institutions for the redressal of their disputes. So getting the caseload is not difficult for these institutions if you compare to the other institutions. Like I'm talking of Indian scenario. I'm not
That's
talking
right.
of London. Yes. So the other institutions which are not associated or affiliated with any industry association, they found it difficult and they died their own death. The live example is ICADR. ICADR had a beautiful campus in Delhi. They still have the campus, is still there, but ICADR is not there anymore. It died its own death because there was no caseload. Beautiful campus, good set of rules, which are still quoted by many disputants and many, you can find them. But there was no business for them. So they could not sustain because the cases were not getting referred to them. So that is where the 5 year back scenario, you say, now the things are changing because it is important for the institutions to not only do the redressal properly, it is for them to make their existence and presence known to the disputants or to the industry where they are playing. So, for example, CIAC, which I represent or I'm associated with, they are making inroads in the industry. For example, the recent seminar in Hyderabad, or one which is going to happen again in Hyderabad and Chennai and other places in the country, what we do, we disseminate the knowledge about the disputes and their redressal through ADR modes into the industry players. So we, when they come to us in the other programs, we have some session on the arbitration, etc. So they know that they have to, if there is a dispute, they have to come to us. Now, the other problem is seeing the role after 5 years. The problem is that if you have the clause of dispute resolution today, the dispute may come after 5 years, 10 years, you never know. So you have to do one thing. You have to educate the industry players or the disputants or whatever, that they should rewrite their agreements. And you would remember, I discussed with you some time back, the novation of contracts. The contracts which they have already, those can be rewritten and the clause should be included, dispute resolution clause with the name of this institution should be included in that agreement. So that in case, in the unfortunate event for them, fortunate for us, if there's a dispute, it should be referred to you. Otherwise, if your clause is faulty or defective, it will not come to you. So the entire ecosystem of the dispute resolution rests on the future of the institutions, not ad hoc, because ad hoc has got no future. I will come to that in time permits. Why ad hoc is not good and why institutions is good. So for the very survival of the institutions, it is important that case note comes to them and they show the results to the people who approach them.
Okay. Um, so far, we've been talking about a lot of issues, but not the core topic which we chose, which is construction and the institutional arbitration. Why do we need a separate institution for constructional arbitrations? So that's the crux of it. Can you please explain?
Dr. Reddy, I am also associated with the Delhi International Arbitration Center as an arbitrator. I'm also associated with the ICA, which is a FICCI's outfit, as an arbitrator. And I have been conducting arbitration from both institutions. See, those are commercial arbitrations. These are simple arbitrations, if you ask me honestly. It's a commercial dispute which has got nothing which is very complex to resolve, and they get resolved by not. You can say it can be done by anybody who is little knowledgeable. But when it comes to the construction dispute, as you know, by very nature of the construction industry, the dispute is number one of high value. Number two, the dispute involves so many features which make it more complicated because the timeline of any construction project is very long, and if the chances of the disputes getting risen are very high. Number two, and resolving them involves very complicated nature of disputes makes it more important that the experts handle those disputes. So construction disputes per se, it is required to be handled by experts. And CIAC by nature, we are only devoted to construction disputes. And since it has been created and established by Construction Industry Development Council, we have got 250 members who are the construction industry players, like contractors, like big contractors and big construction companies or PSUs and all. So they know that their disputes nobody else will be able to resolve, and only the experts which is who are aware about the construction industry's nature will be able to handle those disputes. So that is why I think that the specialized institution for construction at least is very important. And we are seeing it day in and day out that people are not going to any other place but to coming to us for resolving their disputes. Because we have got the panel who are engineers, who are lawyers, who are judges, who have handled this type of thing. If you go to any judge who has spent his lifetime in the dispute resolution to the courts of law, if he has not handled the construction, I don't think, with due respect to his background, I don't think he'll be able to do justice with the entire process.
Recently, I was in a conference.
Hope that answers your question.
Yes, it does. Recently, I was in a conference where one person was sharing his example, where after almost all the arguments were done, one of the arbitrators who was not from a construction industry, on obviously a construction case, he was asking what was the meaning of DLP, and all the parties were shocked, which is a defects liability period. Without understanding that, he went through the entire session of arguments, and towards the conclusion, he was asking basic questions of definitions. So they were taken back, but they could not obviously do anything at that stage.
That itself speaks for whatever I was saying last 2-3
Yes,
minutes.
it does.
People don't know, and still they are chosen as arbitrators, which is very dangerous for the disputants.
Yes. There is an illusion that we can depend on experts, like expert witness, but that is only to some extent. See, it's obviously not possible for everybody to be expert in everything. But if we choose to do something in which we are experts in, obviously we'll be doing a better job. I think that's the ultimate message, which is a takeaway from what you've been saying so far. And in fact, recently, one other point which I wanted to discuss with you is that there is real-time voice translation softwares and things of that sort, which even our Supreme
Yes.
Court has adopted. Those are very costly software, which would be very difficult for an individual to maintain it, an individual arbitrator. But as an institution, it would be financially feasible for you to maintain it. And that's the kind of infrastructure which institutional arbitration could bring, which a ad hoc arbitration cannot bring about. So that was a wonderful
You
session, sir.
rightly put
But any concluding
you
remarks
rightly
that you...
put it. No, I would say that the in order to for India to become an hub of institutional arbitration, I think the institution should also realize and recognize their responsibility to come up to the demand of the time is to come and do whatever to their mind. It is not going to help. So it is important for institutions to make inroads into the industry and keep educating the industry people. Unless the operators in the industry they are not aware of how the dispute can be resolved. One more thing which CIAC is doing is organizing small conferences and system where we are educating the people not only for the resolving the dispute when the dispute becomes a full blown dispute. What we say is if you have a small problem, just make a call to us and get it resolved. We have got our names of the experts have been circulated to people. They can either come to us directly or they can call any of the experts for resolving of their problems. So the dispute doesn't arise. It is important for us to see that the disputes are avoided also. It is not only the business which is important. It is important that the disputes don't arise because ultimately the industry has to grow and the country has to grow. That will only happen if there is no dispute. Construction industry, Dr. Reddy, as you are aware, it is the lot of money which is getting stuck in the entire disputes process. So that is not getting resolved. That is why this Vivad se Vishwas has come up, and to some extent that has resolved the problems of this. That time is gone for that Vivad se Vishwas now. So lot of money is stuck, and if the disputes are not there, perhaps that's the best thing to happen. But I think that's a wishful thinking.
Sure, sir. And this was a wonderful session, and I thank you for the time. And namaste.
Thank you very much. Thank you very much, Dr. Reddy.